In the previous section, we discussed the steps involved in gathering evidence and conducting interviews. Now, we'll shift our focus to what comes next: evaluating evidence, writing reports, and completing the investigative process before it is handed off to the hearing officer. As part of a thorough investigation, it's important to gather all relevant evidence that may shed light on what happened. This evidence can take many forms, including, but not limited to, interviews, conversations with the reporting party, responding party, and witnesses, documents, any written material such as class schedules, reports, or notes, photographs, including images of injuries, locations, or other visuals related to the incident, communication between the parties, text messages, emails, DMs, etc. Medical records. When the party has provided written, informed consent, these can help support or clarify claims. Electronic records, swipe card access, location data, or other digital footprints. Social media, posts, comments, or messages. Note: INWAC does not monitor online content, so it's up to the parties to provide this information if it's relevant. Site visits or expert input. Visiting the location or consulting experts, e.g., mental health professionals, IT specialists. Prior or subsequent conduct by the responding party, only when it has bearing on the current allegation. Prior sexual history. This is only considered when directly relevant under limited exceptions. What makes evidence relevant? Not all evidence carries the same weight. The investigator will carefully examine all submitted or discovered information to determine its relevance. That means asking, does this help us understand what happened? Statements about a party's general character or reputation typically aren't considered relevant. Our goal is to stick to information that helps clarify the specific incident is under investigation. Weighing for relevance. Objective evaluation. Investigators must objectively evaluate all relevant evidence, regardless of whether it supports or refutes the allegations. Connection to the allegations. Evidence is considered relevant if it helps to prove or disprove facts related to the allegations in the formal complaint. Using logic and common sense. Legal training isn't necessary to assess relevance. Use logical reasoning and ask, does this make the facts clearer? Inculpatory and exculpatory evidence. Be mindful of both types. Inculpatory evidence suggests the responding party may be responsible. Exculpatory evidence suggests they may not be. Credibility indicators. If a piece of evidence helps determine whether someone is telling the truth, it may be considered relevant. Inconsistencies. Discrepancies should be noted. But keep in mind that inconsistencies, especially in trauma cases, are not always signs of dishonesty. Important notes. Remain objective. Avoid assumptions or personal judgments. Your role is to present facts, not form conclusions. Remain impartial and free from bias. Institution bears the burden of proof. It is the college's responsibility, not the reporting or responding parties, to collect sufficient evidence. Stay focused. Keep your analysis centered on the specific allegations and whether there is evidence to support a policy violation. Once the initial evidence-gathering phase is complete, it's time to share findings with the parties. Both the reporting and responding parties, and their advisors, if any, will receive access to all relevant evidence, whether it supports or contradicts the allegations. They will have 10 business days to provide written feedback, offer additional information, suggest other witnesses, and/or request that the investigator pursue additional evidence. If either party provides written response or makes request for additional investigation, the written response and any additional information gathered by the investigator will be shared with the both parties and, as appropriate, Each will have the opportunity for further response. Typically, each party will have 3 business days to review any substantive information and provide a written response. This phase helps ensure transparency and gives both parties an equal opportunity to participate in the investigation. The investigator must consider all feedback before drafting the final report. After considering any final responses and, if applicable, completing additional investigative steps. The investigator, normally within 5 business days, will prepare a final report that clearly summarizes all relevant evidence. This report is sent to each party and their advisor at least 10 business days before the hearing, giving them time to review and respond. Both parties will receive a simultaneous written notification that the report is available. If a party chooses to submit a written response, it must be provided at least 2 business days prior to the scheduled hearing. At this stage, both parties may also submit impact or mitigation statements. Please note, if a party knew or should have known about evidence during the investigation but did not provide it, that evidence likely won't be considered during the hearing unless there is good cause for the delay. Your final report is more than a formality. It becomes the core document that the hearing officer will use to determine if a policy violation occurred. It should be thorough, neutral, and well organized. Goals of the report: document the process. Show what steps were taken. Compile the evidence. Present what was gathered. Summarize the facts. Outline what was learned during the investigation. Keep in mind, you are not determining responsibility. You are only presenting the relevant information from your investigation. Contents of the report: cover page, table of contents, recommended for reports longer than 10 pages. Overview, methodology, evidence summary, investigative summary. Let's break down these key sections. Cover page: include case identifier, report title, names of the investigator, reviewer, and the date. Table of contents: helps the reader quickly locate information. Use section titles and page numbers. Overview: provides context for the report. Include allegation summary. Names of involved parties. Relevant policy violations. Timeline of when notice was issued. Methodology is how we did it. Briefly describe intake and assessment. How the parties were notified, pre-investigation meetings, interview, process, review of evidence. Any additional information submitted post-review. The investigation summary is where you start laying out what you actually found. Include the following. Interview table. Include a list of everyone interviewed with names and roles, for example, reporting party, witness A, witness B, etc. Exhibit table. List all physical or digital items referenced in the report. Include the notice of allegations and other documentation used in the investigation. Summary of relevant evidence. What we learned. Break this down into categories like testimonial, what people said, documentary, documents, emails, texts, demonstrative, maps, diagrams, real evidence, photos, physical items. Chronological narrative, present events in order, include relevant background information for clarity. Incapacitation claims. If applicable, clearly describe the behaviors and perceptions surrounding any claims of impaired judgment or consent. All exhibits should be included as appendices. Here are some other important considerations. Always record interviews and send transcripts and notes to the interviewee for accuracy confirmation. Never include protected or sensitive information such as medical details and accommodations without explicit written consent. Number the lines in your report to make referencing specific sections easier. Lastly, always keep in mind the hearing officer's job when writing your report. Your report should help them answer the following. What was the conduct in question? Was the conduct based on sex? Was it unwelcome and non-consensual? Does it meet the definition of a policy violation under INWAC's guidelines? Now that we know the basics of investigations, let's move on to some other considerations when conducting interviews. Our next section will cover serving impartially, cultural competence, and trauma-informed investigation.